Welcome, everybody, to the ongoing series of Schoeneck King covering the COVID-19 crisis. Today, we're going to talk about implications for employee benefits due to COVID-19. My name is John Gotzo. I'm going to be joined by my colleague in our Employee Benefits Department, Aaron Pierce. The way we have the presentation divided today is the first part I'm going to discuss welfare plan issues with respect to COVID-19. Aaron is going to tackle retirement plan issues. Today we have about 30 minutes for the presentation, so it doesn't allow us to do a deep dive into every topic that we'd like to. We do have a number of employee benefits information memos on our website that go into a little bit more detail on some of the topics that we are discussing today. So please visit that website if you're looking for a more detailed description of what's going on in connection with the topics that we're going to talk about today. But one thing I'd like to talk about in connection with the just what we're all experiencing in connection with COVID-19, it's really been an incredible experience, I think, for me and maybe others out there. It's an unprecedented times, but dealing with clients on a day-to-day basis, we really see what it means to them to work for their employees, what it means to them to find the right solution and work through this crisis. So I have all confidence in seeing what our bond attorneys have done and what our clients have done that we will all get through this. If we could have the next slide here, please, Kathy. Oh, we're having a technical difficulty here. We're sorry for the delay. We're all trying to pull it together, I think, as many of you are working from our homes, and we're having some technical difficulties with respect to the slides. I'm going to give it another moment here. Okay, well, I hope our slides will catch up with us here. I guess we'll just have to start off by winging it a little bit. Our first slide is with respect to furloughs and leaves, and I'm sorry you can't see it right now. But really, this is an issue we're all facing, especially here in New York, in connection with what's going on and the fact that businesses that aren't labeled essential businesses by the governor have had to close their operations, have to have less output as far as what they're working with on site. So therefore, many people have had to change their workforce, change hours, et cetera, in response to this. So as a result, we're getting a lot of questions with respect to furloughs and leaves and what can happen. And in those circumstances, let me define what we're really talking about here. Furlough and leave, I'm talking about a situation where there is not a severance from employment. We're really talking about an extended absence from employment where there is some kind of thought about a return at some point. So we're not talking about a true severance from employment, but we are talking about a situation where hours are reduced to zero. People are not working due to the situation where there's a downturn or basically mandatorily they can't come into work. So that's the type of situation that we're talking about here rather than a true severance from employment. Okay, looks like we have our slides back. I apologize. So in this situation, I think really the number one consideration that we're talking about on the welfare benefit side is what are we going to do with our programs and what do the terms of our plan say? Because the terms of the plan really dictate what we're going to do and what we're able to do with respect to our employee benefits. So the first thing to think about in the situation, I know many people want to do quote unquote the right thing. They want to extend benefits for a period of an indefinite layoff, or excuse me, furlough or leave. But we really have to look to the terms of our plan to understand whether that's permissible or not. And one thing we don't want to do is unilaterally go ahead and extend coverage to folks if that's not permitted pursuant to the terms of the applicable plan or contract. So advice number one is do not unilaterally extend that coverage. You want to be talking to your insurance providers. You want to be talking to your stop loss carriers with respect to any changes that you are contemplating, and make sure you get some kind of written sign off. Now, certainly I've seen already many insurers responding to the situation and sending out guidance indicating that, hey, if you have a situation where people are on furlough or layoff or aren't having as many hours as what was originally contemplated, we're going to cover that. We're going to still cover those individuals under our insurance contract. Some of them are specifying a period of time. Others are not. These are all welcome pieces of guidance, but certainly my recommendation would be to ultimately get that sign off from the insurer in writing with respect to your particular plan, and just don't rely on a single generic reference from the insurer. Same goes with stop loss carriers. If you have a stop loss carrier, if you're a self-funded plan, you want to do that, get that right off from the stop loss carrier as well. Communicate with your employees what those changes may be. You want to have clear communications about how long this is going to extend for, whether it's in connection with a furlough and leave. And if you have some sense of time, then certainly communicate that this is going to be an extended period until the end of that time, and then maybe we're going to have to reassess. But we want to make sure that people understand that this is not something that may be ongoing past this furlough or leave period. Affordable Care Act considerations. Many of you may be what's considered an applicable large employer, which means you have 50 or more full-time employees based on the prior year. If you're an applicable large employer, you're really subject to the employer shared responsibility requirements of the ACA, which bases full-time status on a measurement period and a stability period. Now, many of you may be using what's referred to as a look-back measurement period in order to determine full-time status, and that was really looking at the prior year or prior measurement period. It's often a period that ends very shortly before the plan year to determine whether an employee is full-time or not. If that's the case, you might have individuals who are in full-time employee status based on what their hours were last year rather than what they are right now. And that's really what's considered your full-time status for the stability period. That would be what you'd be reporting on your 1094Cs and 1095Cs next year. If someone is in a stability period and there is in a furlough or leave situation and they are not terminated, that will potentially subject you to a penalty if you're not offering them affordable coverage during that period. So if you are in a situation where you're in a furlough or leave and you're unable to offer coverage to an extension for the period of that furlough or leave, you got to think about that there may be implications under the ACA. Now recall, in order for a penalty to apply, the individual has to go out on the exchange for that month and get exchange coverage, and also have that coverage be subsidized on the exchange. So there are a few things that have to happen first in order for the penalty to be applicable. But just be aware that if you're in a situation where someone's in a stability period as a full-time employee and we're not able to offer them affordable coverage, whether that's because we're offering them COBRA at the full rate or not, there is a potential for an ACA penalty for those furlough and leave periods. COBRA, again, if your terms of your plan indicate that the individual is no longer eligible to participate in the plan, then you're going to offer them COBRA. We're talking about all our group health plans, vision, dental, etc. Health FSA may be applicable depending on how much of reimbursements that the individual has received during the year by that point. You can choose to subsidize COBRA. That is something that's optional to you, and if you do, that would address perhaps the Affordable Care Act issue as far as providing affordable care or affordable coverage to your full-time employees. Just know if you're going to subsidize coverage, this does call into question an issue with respect to the marketplaces. Now, these marketplaces are the marketplaces established by the ACA that individuals would have the option to go to following a termination of employment. The marketplaces are subject to open enrollment periods and special enrollment periods. Under the guidance now, as it stands now, the best reading is that if you subsidize coverage and you stop that subsidy, say for example, after a month or 2 months after the individual loses coverage under your plan, that will not be a special enrollment event for the individual to get into a marketplace coverage. So that individual may be stuck on your coverage for a longer period than is intended. So that is one thing to think about when you're talking about subsidized coverage in the ACA. Next slide, Kathy, if you can, please. Life insurance, to the extent that you have a loss of coverage, most policies offer a conversion right in connection with that coverage. Sometimes that conversion right is the obligation to notify folks of that conversion right is placed on the employer. Please figure that out amongst you and your insurance carrier who has that obligation. You don't want to be in the situation of having to self-insure an insurance benefit because a proper conversion right notice was not provided to your employees. Severance plans, just make sure to check them to see if a furlough or leave would potentially trigger the benefit pursuant to the terms of the plan. Some of you may have formal severance plans, some of you may have informal severance plans. Check the terms of the plan just to make sure you're not unwittingly triggering some type of payment event under the terms of those plans. Premium payments, we all know, we've experienced this in the past with people going out on leave. Paying the obligation for the premiums will be different now because you won't have a regular pay likely during an unpaid leave or furlough. So you got to figure out how the payment's going to be made, how those premium payments are going to be made. And usually your options are to either have them be prepaid, pay as you go, or catch up. A lot of employers we're talking to are considering to pay the employee's share of the premium, and that's a noble gesture, certainly, and something that you can consider. Also, considerations will have to be given to when those employees return. How is that going to be repaid? What if they don't return? Is the employer going to be left with the full premium payment and an inability to recover that amount? So just other considerations to think about when we're talking about premium payments and how that's going to work in a furlough or leave situation. Next slide, please. COVID-19 coverage, as we all know, the big mandate is get tested. We want to understand who may be infected, who may be having the virus. So we want to have as much testing as possible. In order to do that, we want to make it as easy as possible. So early on, with respect to New York and many other states, have adopted rules for their insureds that basically say there's no cost sharing on an in-network, or New York's rule was no cost sharing on an in-network provider visit with respect to testing for COVID-19. And the same goes for a visit to an emergency room when the purpose is to be tested for COVID-19. Initially, after that occurred, there was some sense of, after the New York State Department issued that, well, what about self-insured plans? How will they respond? And it initially was something that was optional, but under the Families First Coronavirus Response Act, that did not become optional anymore for self-insured plans. And it basically mandates the same type of cost sharing or lack of cost sharing that would be applicable with any testing or visits to test for the detection of COVID-19. So, now both our insured plans and our self-insured plans, there's no cost sharing. You go in fully covered when you go in to test for a COVID-19 diagnosis. Next slide, please. And again, that's any interaction with a healthcare provider office, an urgent care center, or an emergency room. It's effective immediately. It's going to be for the duration of the public health emergency. It's going to apply to most health plans. Again, we talked about being applicable to self-funded plans. Retiree plans, as of right now, doesn't appear to apply to retiree plans. Maybe we'll see some more guidance on that. And one thing to know, it does not mandate coverage for treatment. This is only for testing that the coverage mandate is for without the cost sharing requirement. Next slide, please. One thing that comes around with all these mandates to cover without cost sharing is HSAs. So to the extent that you have an HSA, general rule is that you can only be covered by an HDHP. So that causes problems if you have coverage that comes into play before the HDHP deductible is satisfied. The IRS gave us helpful guidance in Notice 2020-15 that testing and treatment for COVID-19 prior to satisfying that HDHP deductible will not cause the plan to lose HDHP status. So that was good news. We know that we can now go in for those testing and you're not going to lose your HSA, HDHP status and continue to make those contributions to the HSA. Telemedicine. Over telemedicine, that can be done without jeopardizing your HDHP. Expanding telemedicine coverage beyond that coverage for COVID-19 is problematic. As of right now, we don't have any guidance saying that you can cover telemedicine totally without it being subject to the deductible of an HDHP. We look for further guidance on that, hopefully in the near future here. Kathy, can we go to HIPAA privacy? One last note, CMS recently issued guidance reminding us in HIPAA, in an emergency, HIPAA is not set aside. Basically, under this guidance outlines one PHI can be disclosed without authorization. And those circumstances can be to public health authorities, to persons at risk of contracting or spreading the disease if that's permissible under other law, and to family, friends, and others involved in the patient's care. One thing to note with HIPAA is that in many cases, the health information may not be HIPAA protected. So this may be a situation where you're not talking about, if we remember our HIPAA rules, it talks about where the source of the information is from the group health plan. If you receive the information outside the group health plan from, for example, the individual themselves, that's not HIPAA protected, but it may be protected by other privacy laws. Another thing to consider with respect to HIPAA is that, a lot of us are working from home, working remotely, and in that cases, the HIPAA rules still apply. We want to keep our workspaces clean of any PHI. We want to make sure that any PHI that we print out is maintained in separate files. We make sure that we have secure lines from electronic PHI standpoint in order to ensure that those HIPAA rules are still being satisfied while we're working remotely from home. So with that, I'm going to pass it to my colleague Aaron to talk about the retirement plan issues in connection with COVID-19.
Great, thanks, John. So I'm going to spend the next couple of minutes talking about some of the issues we've been seeing our clients facing in their response to the COVID-19 emergency. I really want to start with the access to retirement plan benefits. So certainly when we have employees who are either furloughed, working on a reduced capacity, may have a spouse who has lost the job, there may be a need for many employees or a desire to get access to funds that they've either contributed or have been contributed on their behalf to a retirement plan. So the general thing to remember is that the terms of the plan apply. So if we have put people on furlough or leave without terminating their employment, they generally would not be eligible to start receiving distributions from that retirement plan unless the plan permits in-service distributions. So many plans do permit in-service distributions under specified circumstances, like for employees who reached age 59 and a half, or commonly under 401k plans and 403b plans is hardship distribution. So under the hardship distribution rules, a participant who has not terminated employment may elect to receive a distribution of amounts from their plan if they've incurred a sudden and immediate financial need. And certainly there are circumstances in which folks in this situation could qualify for a hardship. The two of the more common ones that might be applicable in this situation would be a hardship distribution for medical expenses not otherwise covered by health insurance, or amounts needed to prevent eviction or foreclosure. But there is a relatively new category of hardship distribution that first became available as a result of some legislation that was adopted at the end of 2019 that allows a hardship distribution to be made in connection with a federally declared disaster. Certainly for folks in New York and California and Washington, where the president has declared major disasters in connection with COVID-19, that would trigger the availability of hardship distributions in this circumstance. It is unclear whether folks outside of New York would have the ability to take a hardship distribution here, because the president hasn't declared a disaster in those areas, but instead it has declared a national emergency. We think it very likely that the IRS will interpret this broadly to allow hardship distributions in that situation as well, but we're going to have to stay tuned and see if we get anything from the IRS specific on that. One of the important things to remember is that just because the law permits hardship distributions in these categories doesn't mean your plan does. So you need to look at the terms of your own plan. If the plan doesn't permit hardship distributions, but you want to allow it, the plan would need to be amended to do so. If you already have hardship distributions in your plan, but you haven't gotten around to amending it to include the new circumstance for federally declared disasters, which many plans haven't because the deadline is still quite far off, you would need to amend the plan to add that provision as well. The important thing for your participants to remember, however, is that just because you're eligible for a hardship distribution doesn't mean you get out of the taxes associated with that distribution. So with a caveat that these rules may change if the legislation that is currently moving through Congress gets passed, under current tax law, hardship distribution is subject to ordinary income tax and would be subject to the 10% penalty on early distributions if the participant is under age 59 and a half. Again, that may change depending upon what happens with the stimulus package that is currently working its way through Congress. Kathy, can you advance the slide, please? Thank you. Another area where we've seen a number of questions from clients is regard to flexibility in terms of the timing of making contributions to their retirement plans. Certainly many plans may have a practice of making contributions, be it a matching contribution or an employer profit sharing contribution, on a periodic basis throughout the plan year, either each payroll period or on some other basis. We've gotten questions from clients to say, do I have to do that? Can I defer making those contributions until later in the year when our cash flow may be better? So the good news is that most retirement plan documents do not require that employee contributions be made on a periodic basis throughout that year. Now, it's common practice that people do that, but it is the rare plan document that says that the matching contribution has to be actually contributed to the plan on a periodic basis. Instead, the contribution deadline is typically based upon the code rules for determining the deductibility of a contribution or for what year that contribution applies to. For taxable entities, that generally means you have until the tax return due date with extensions for that entity's corporate tax return. So that would mean a contribution for 2019 under the law could be made as late as September 15th for a calendar year taxpayer on extension for their corporate tax return. So you may have some flexibility to defer contributions that are due, that you intend to make, but you may want to take advantage of the ability to defer those contributions to a later period in the plan year to help alleviate some immediate cash flow issues. Of course, check the terms of the plan before changing past practice. You certainly don't want to be in a situation where you're violating a specific term of the plan, although it's unusual. Your plan may have provisions that require contributions earlier. And certainly for unionized workforces, your collective bargaining agreement may have implications as well. There are collective bargaining agreements out there that specify the timing of employer contributions to retirement plans. So you make sure you don't run afoul of those rules. Also remember that none of this applies to employee contributions or loan repayments. So if you are withholding amounts for contribution to a 401k plan or a 403b plan from someone's pay for contribution to the plan, do not delay those contributions. Those should be and continue to be remitted to the plan as soon as they can reasonably segregate it from your general assets. And we do not expect any relief from that rule from the IRS. Next slide, please. In addition to flexibility in terms of the timing of contributions, some employers are looking at whether they have the option to suspend making employer contributions altogether or reduce the amount of those employer contributions. Generally, your ability to do that is going to be dependent upon the terms of the plan. As a general rule, you typically can reduce or suspend contributions with respect to future compensation. You may still have flexibility to change your contribution structure for comp that has already been paid in 2020 if the participants have not yet satisfied the allocation conditions specified in the plan to earn that contribution. For example, if your plan says that in order to share in the matching contributions made for that year, you've got to complete 1,000 hours of service and be employed on the last day of the plan year, nobody earns a right to that contribution for 2020 until you get to the end of the plan year. So you would still have the ability to say, we're going to amend the plan to eliminate or reduce the amount of that employer contribution. A substantial caveat for that, however, is for safe harbor 401k plans, and these are plans that make or promise to make specific contributions in order to avoid non-discrimination testing that applies to 401k and matching contributions. There are restrictive rules that apply to safe harbor plans. Generally, you can only suspend a safe harbor contribution if the employer reserved the right to do so in the safe harbor notice that it gave prior to the beginning of the plan year, or if the employer incurs an economic loss. And an economic loss is something more than just a temporary cash flow crunch or adverse business conditions. It would require a showing that the company is actually operating at a loss on a P&L basis, as determined by the accounting rules. In both circumstances, you need to give at least 30 days advance notice that you are discontinuing the safe harbor contribution, and then that the applicable non-discrimination rules would have to be satisfied for that year. Next slide, please. Great. Similar rules apply for defined benefit plans. So if you are one of the few employers out there that still has an active defined benefit plan, you do have the flexibility to amend the plan to freeze or reduce benefit accruals. Advance notice does have to be provided at least 45 days for large employers and 15 days for small employers. You have to keep an eye out about the timing of that. To the extent that the participant has already earned the right to an accrual, then you couldn't take away that accrual or reduce that accrual, at least with respect to compensation that has already been earned. This generally is not going to have an immediate impact on your contribution obligation to a defined benefit plan because of the way those contributions are determined on an actuarial basis, that any relief would be relief that would probably occur in later years. There are being some proposals floated for funding relief for defined benefit plans, and stay tuned for an analysis as to whether the stimulus bill includes any funding relief for defined benefit pension plans. Next slide. One other issue that I want to mention for defined contribution plans that we need to keep our eye on is the partial termination rule. So these rules require or provide that if there's a substantial termination or layoff of employees that is initiated by the employer, that can trigger a partial termination resulting in 100% vesting for any affected employees. So if you let go more than 20% of your employees are no longer participants in the plan because they've been terminated, and the plan had a vesting schedule applicable to employer contributions, those terminated employees would become 100% vested in their accounts. It's really unclear how this is going to apply in this kind of evolving situation where we have may have employees on extended furlough who may then be brought back to employment at a later date. So we have to watch out to see if we get guidance from the IRS on how that impacts us, but it is an issue we need to keep an eye on. If we're letting go a significant number of employees, we may trigger that partial termination. And then finally, on the last slide, just a quick preview of some of the things we may be seeing in the stimulus legislation that hopefully the Senate is going to be voting on later this afternoon, and then we go to the House. It includes a number of retirement plan provisions. The most significant being is a new in-service distribution opportunity that would allow participants affected by the coronavirus situation to get a distribution of up to $100,000 without that 10% early distribution penalty tax. In addition, the ordinary income tax could be spread out over a 3-year period, and the participant actually could have the ability to repay that distribution back to the plan once their financial situation stabilizes. It would also increase the loan limit from $50,000 to $100,000, would allow for extended due dates for participant loans to avoid loans going into default, and would also suspend any required minimum distributions that would be due for 2020. So with that, John, are there any questions that you saw that came through on the Q&A that you would like to address before we let folks go?
Sure, there are some. I'll try to group these together of kind of the commonalities here. One question was, if you choose a furlough option, are you able to offer associates COBRA even when there isn't a separation of employment? So this really goes back to the issue of, what do your plan documents say? So you might have a situation where obviously that furlough is going to reduce the number of hours that the individual is working. So if pursuant to the terms of your plan, the plan says if you go from being a full-time employee, and maybe that's defined as regularly working 30 hours a week or more, if you go from a full-time employee to a part-time employee, then coverage ends with respect to medical insurance. So that would be a scenario where you would have a COBRA event, unless, as we're speaking about, the insurance company is modifying its rules to say, normally we have a scenario where you have to be working 30 hours a week pursuant to the terms of the contract. If they're allowing employers to modify those rules and continue to provide the coverage, but that's certainly something that you want to get the sign off from the insurance company from, if they are doing that, before you allow folks to continue coverage, even if they're on a furlough or working anything less than what the terms of the insurance contract say. Similar question with life insurance. The question's about, you're not really terminating an employee on furlough, so would we terminate the life insurance? Again, especially life insurance contracts typically have some type of actively at work provision to it. So when someone goes from 30 hours a week to 0 hours a week, for example, under the terms of that life insurance contract, it's more likely that they no longer will be eligible pursuant to those terms. So that would be a situation where unless there's some guidance or you get official sign off from the insurance company, the terms of the insurance contract would control, coverage would end, for example, either that day or at the end of the month. And therefore there would be a conversion right in connection with that loss. And that's the issue that we were covering previously, is we just want to make sure whether or not who's handling the conversion notice, and make sure that gets out to folks, because the failure to do that could result in a claim that, hey, you're, as the employer, should insure this benefit because you never sent out the proper conversion notice, and I suffered a loss as a result of that. So that's what to think about with respect to life insurance. Similar concept as with health insurance. There was one comment about receiving guidance that the $0 cost share for testing of COVID-19 was recommended but optional for self-insured plans. That may have been the guidance early on. Certainly the first piece of guidance we received related to COVID-19 testing with respect to, at least here in New York, New York insured plans. And at that point, it was optional for self-insured plans to either cover it or not cover it. With the Families First Act, that now, at least for testing, takes that option out of play, and it's required for all plans, or most plans. Again, there appears to be an exception for retiree plans. Someone asked what distinguishes between a furlough and a leave. Again, I think it's really semantics and the terminology that we're using here. Really, furlough leaves, for the purposes of this conversation, are meant to talk about situations where there hasn't been a true termination of employment, separation from service. It's a reduction in hours. They're both meant to describe a situation where someone it continues to be an employee of the employer. It's not officially terminated, but just isn't working. So we're using furlough and leave kind of in the same context here for purposes of this presentation, basically meaning at any period. And again, we're not talking about protected leaves or any leave that's provided under law. We're talking about an employer leave that results of a downturn in business, or the current situation in New York with respect to non-essential businesses and continuing operations there. So again, for purpose of this conversation, that we're kind of talking about them synonymously.
John, can I chime in with a couple of answers to a couple of questions that people raised regarding the loan changes?
Sure.
The first thing, of course, remember that these aren't enacted yet. They have been part of the proposals. We believe they're part of the agreement that was reached between Republicans and Democrats in the Senate last night, and should be part of the legislation that the Senate is voting on later today. One of the questions was would the plan need to be amended to reflect those loan changes? And the answer to that is yes. There will be amendments required to allow for the increase from 50,000 to 100,000, and to change the due date rules or the loan repayment rules. You will have an extended period of time in which to get those amendments adopted, even though you could start implementing those changes immediately. But remember that your ability to implement those changes is going to be dependent upon your provider's infrastructure, and it will take them some period of time to modify their systems to allow for loans in excess of $50,000, or to change the normal due date and grace period rules for participant loans. Another question was would there be a sunset date on that? And the answer to that is yes as well. These are intended to be temporary changes. I don't recall how temporary, but they would sunset after a period of time when we go back to the normally applicable participant loan rules. And with that, John, unless you have any other questions that you want to address, I think we're about 10 minutes over our stated end time. So unless you have anything further, I think we probably sign off now.
Yeah, well, we really appreciate everyone's attendance today. We're monitoring the developments. I'm sorry we couldn't get to everyone's questions today, but we are monitoring the developments as they occur. We continue to issue guidance as they occur. As I indicated, you can look at our website. We have a number of information memos, both from the perspective of employee benefits, as well as our labor law department. Labor and Employment has a number of memos on this or these issues as well. There were some questions today that were asked related to PFL and some of the things that are more on the labor and employment side. And we certainly have resources for that questions. We also have a weekly COVID-19 seminar that's going on, that's run by the Labor and Employment Department, where those issues get addressed. So we continue to provide information regarding those issues as well. But so keep looking for updates. We continue to monitor the situation. Thank you for tuning in today. We apologize for some of the technical difficulties. We're hoping to get this right. As I said, like many of you, we're all working from home here and working with those challenges as well. but we appreciate your attendance and hope to see you at future webinars that we'll be running. Thank you.